Welcome to Module 7, Faculty Relationship with the Institution and Faculty Employment. This week, we will begin to explore the employment-related issues surrounding faculty members. As you will learn through our readings this week, the faculty employment relationship with higher education institutions is a very Faculty members are afforded certain rights through their employment agreements with higher education institutions. As a result, faculty contracts can take a myriad of forms and are dependent on the institution. A faculty contract could include formal written contracts, letters of appointment, on rare occasions oral contracts, or another process. Faculty handbooks could describe the responsibilities of faculty members on campus, outlining policies and procedures. If the campus has a negotiated agreement with an agent on behalf of the faculty, the policies and procedures may be outlined in this agreement. Within this document, if tenure is a process offered by a particular institution, the terms of the tenure process should be clearly outlined in the handbook or agreement for all faculty members, as the tenure process can be viewed as a contractual relationship. According to the American Association of University Professors' 1940 Statement on Principles of Academic Freedom and Tenure, quote, tenure is a means to a certain ends. Specifically, 1, freedom of teaching and research and of extramural activities, and 2, a sufficient degree of economic security to make the profession attractive to men and women of ability, end quote. This means to an end comes with specific rights and responsibilities and can be a highly volatile process when processes are not followed. Your Kaplan and Lee reading for this week will provide you with a multitude of great examples of legal cases involving tenure issues and granting tenure, denial of tenure, and removal of tenure. Additionally, part-time or adjunct faculty bring a new host of legal issues with regard to employment. Some part-time faculty receive contracts for a period of time, others for a specific term, with others being eligible to participate in unionized negotiated settlements. With the increased hiring of faculty in part-time roles, the case law has continued to grow, addressing the hiring, course load, and termination of adjunct faculty. One of the most complex legal issues surrounding faculty employment is that of collective bargaining. Collective bargaining is the process where individuals within an organization or a union grant the authority to the organization to negotiate on their behalf with their employer. Interestingly, you do not have to be a member of the organization, association, or union to be represented, as all individuals who would qualify as members would be covered. Federal law does not regulate higher education collective bargaining for public institutions. Instead, the states do, and the collective bargaining abilities for public institution faculty vary from state to state. The National Labor Relations Board does have jurisdiction over private sector labor relations, which private higher education was deemed to fall under in the 1970s. For this week's case example, we will be exploring one of the landmark cases surrounding collective bargaining for faculty and staff at private institutions. In 1975, a group of faculty, the Yeshiva University Faculty Association, submitted a petition to become a certified bargaining agent for the full-time faculty at some of the Yeshiva University campuses to the National Labor Relations Board. Yeshiva University was opposed to the faculty utilizing a bargaining agent, as the university did not deem that the faculty were eligible to be certified as a bargaining collective. Their argument was on the basis that due to the university's classification, the faculty were not eligible, as they were considered managerial and supervisory personnel, as they were involved with university governance and setting policies. Despite the university's objection, the bargaining unit was certified by the National Labor Relations Board. The university refused to bargain with the newly formed organization representatives. The National Labor Relations Board filed a suit against Yeshiva based on their refusal to acknowledge or work with the certified bargaining organization. The initial case in the circuit court determined that because the faculty members were considered to be managers, they were not eligible to form a union under the National Labor Relations Board jurisdiction. Upon appeal to the Supreme Court, the decision for the university was affirmed in a 5-4 decision. In utilizing the statutory definition of managers as individuals who can act on behalf of their employer utilizing their individual professional judgment, it was determined that the Yeshiva University Faculty Association did not have the ability to become a certified bargaining entity. This decision has had an impact on the ability for faculty at private institutions to be able to effectively form collective bargaining organizations.